KTRS legal expert. He's our friend. And before you leave, I got 2 tickets I need you to work on for me.
It's nice to see that all of the
He really
the
wants
reforms that we have been working so hard to show that the corrupt municipal court system must be changed, that at least you are using the final days of that to your advantage.
Oh, yeah. Well, I would love for it to go away. But until then,
Let's get the points moved.
Until then, I have to play. I can't just, disarm unilaterally.
I told you to stay out of North County.
He really just wants you here so he can talk to you about his tickets.
That's the only reason I'm here.
So in 2006, some police officers arrest some scalpers. They then take the tickets, use them for the World Series, and then put the tickets back in the evidence room.
Which is worse than what the people originally that had their tickets confiscated were alleged to have done in the first place.
Yes, the rumors are that they knocked over or they pinched the scalper so they could take the tickets for their own benefit. But that happened in 2006. Scott Sherman, why are we still talking about this?
Because the disclosure of the internal affairs investigation done by the city of St. Louis was supposed to be something we could all see under the Sunshine Law, something that you and I are a little familiar with.
Right.
When the public or an agency that is a public agency, such as St. Louis City Metropolitan Police, does something, the public has the right under the Sunshine Law to see what that was.
Great.
And not have what we call secret or closed meetings, i.e. secret police investigations.
So we still don't know who these police officers were.
We're going to find out, because the city of St. Louis police officers that appealed 2 distinct trial decisions and 2 distinct series of appeals have now won in the 3rd series of ticket scalping cases.
The police officers lost.
They did. They lost.
They lost big, too, right?
They lost huge. Here's kind of how it went down. Originally, a citizen said, hey, I want to know what went on with this investigation. And he went and filed suit and won. And then the police department, or at least one of the members of the police department, who may have been implicated or involved in this, said, hey, let me intervene in that. I want to be involved in the appeal of this because the police board's going to appeal. And this person came into the case, and then they lost on appeal. However, once the police board and the police officers that didn't want it disclosed lost in what they call Chasnoff 1, the police department said, well, wait a minute, we need to file suit to protect this stuff because we don't want it out. So they sort of snuck into the first one. Then the second one, they had a trial, and that was appealed. So they've lost all the way through.
Now they can appeal to the Supreme Court if they want to.
Yeah, if they want to do that, they are welcome to do that. But the basis of the case is interesting. When they did an internal affairs investigation, they gave them a sheet of paper. It's called a Garrity statement. And essentially it says this. Hey, we're going to do an internal affairs investigation. You don't have to talk to us. You have the rights under the Fifth Amendment and the Constitution not to talk. And if you do talk, we won't use this in a criminal proceeding. But if you don't talk, we'll probably fire you. So it's not coerced, but it's a sort of Fifth Amendment right to remain silent.
Right.
What the police are saying, what they said in the case is, hey, by providing us with this statement, you made a promise that you would keep this secret. What we said was going to stay in-house, was going to stay in the department.
Right.
And the Court of Appeal said, no, not really, not so much. What they promised was they wouldn't criminally prosecute you.
Right.
They also made arguments that their conduct, which was subject of the investigation, is so personal that it shouldn't be disclosed, a right of privacy. Now, here's the difference. There's a right to your personal file and a right to your personnel file. What you do on the job, that ain't personal. Your social security number, if you've had psychiatric care.
Well, but hold
that
on a second.
is
Hold on a
personal.
second. But if KTRS fires me and somebody wants to know why, KTRS will say, I can't disclose it. It's a personal matter.
The Sunshine Law doesn't apply to private businesses. This is the open meetings for public business. This is good government, transparent government. The police department is an employer, but it's a public employer. So what they said is there's no law, no constitutional right.
The public's
to privacy.
right to know is more important than the officer's right to remain private.
Yes, and what the police were saying is that the Board of Police Commissioners is compelled to keep it private. They can't disclose it. And the trial court said, and the Court of Appeals has said now 3 times, and trial court said 3 times, no. That's not true. Maybe they can keep it private, but it has to be personal, not just personnel. And all the stuff with the ticket scalping is on-the-job conduct. It's not people's private medical information or anything that you could consider a right of privacy. This is bunk, and it's cost the taxpayers of the city of St. Louis now over $100,000 to argue this bunk.
That's why we have Scott Sherman, because he explains it in a way that even local yokels like us can figure it out. Scott Sherman, legal analyst with KTRS. When are you filling in next? You got any schedules?
You're the program director.
Yeah.
Let me know.
All right, take care of my tickets, and we'll talk.